Hello, my name is Jeff. This is 2A Self-Defense Law. If you notice, I took away castle tutelage. I won't be using castle tutelage anymore. It's going to be 2A Self-Defense Law. We have been working a lot lately on the innocence standard and what happens to people when they do not follow the innocence standard. One of the issues that's been having a lot is brandishing. Does brandishing help your case or hurt your case? There is a statistic out there that I see every once in a while, and I get it in class every once in a while also. And it basically says, well, I've seen on active self-protection's videos that if you present your gun 29 times out of 30, the bad guy will run away. Well, why are you presenting your gun? You know, in some states that is an assault. Some states that is a brandishing law. Some states is not a brandishing law. What I'm trying to really get to you is this. What is your narrative going to be saying about you by just willy-nilly taking a gun out and hoping and praying that the bad guy goes away? I've been saying a lot, and I've been giving a lot of cases where someone will show the gun and it doesn't deter the people, and they are forced to shoot people, and at least one out of the 3 cases that I've showed you, given to you in the past few videos, have gone to jail. Why am I talking about this? It's very simple why I'm talking about this. When I teach you something, I want you to be on the far safe edge of what the law will be. And with that, I give you the information that will help you with a large percentage of what self-defense law is, and that is innocence, imminence, proportionality, avoidance, and reasonableness. I've talked to you about people diving into the law a little bit more, and all that white noise out there. And you know, I teach you, you know, the 80-20 rule applies here. Cause and effect. All right. I give you the cause, innocence, imminence, proportionate, avoidance, and reasonableness, and it has the effect of the 80%. So that 20% of information is going to have 80% of the effect. But what people will do is they will keep on borrowing in there, and it gets them into trouble. I am part of a Facebook group as far as instructors go on the legal side of it. And one of the members came up with this, and it is Florida law 776013, home protection, use of deadly force, presumption of fear, and death of great bodily harm. Now, when we deal with this, there are certain protections that the law will give you, and that is presumption of something, presumption of fear, presumption of innocence. And it really has a specific set of facts that are involved with it for you to have that presumption. Now, when I talk about presumption, all that really is an added effect that will help your narrative in the long run. But my God, don't rely on the presumption, because some of these presumptions, if you follow the law, may look bad to the jury. Now let's go through this. A person who is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to himself or others or another when using defensive force that is intended or likely to cause death or great bodily harm to another. Now this is where the law gets a little bit murky in. The person against whom the defensive force was used was in the process of unlawfully or forcefully entering. Now, we're dealing with Florida State here. Other states won't have this. So when I teach you guys, well, yeah, if you're in California, you can't shoot through the door. But in Florida, there is a statute that you can shoot through the door because you have a presumption of fear. My thing is you are not in imminent threat of death or great bodily harm, but what this statute allows you to do, that if someone is going to gain entrance into your domicile, your home, you have the presumption of fear. Now, what does that presumption of fear give you? That you are an imminent threat of death or great bodily harm. So does that law give you the right to shoot through the door? I'm not so sure. Why would I want to teach you presumption? Go by innocence, imminence, proportionality, avoidance, and reasonableness, and let the lawyers presume that you have a presumption of innocence, a presumption of fear, whatever the presumption is, because presumption can be taken away from you. Even if it gets to these people, these are 12 broccoli stalks that I call jurists. You do not know how they are going to react to, well, he had a presumption of reasonable fear, so he shot through the door to kill somebody. Does that really look good? And in a moral instance, is that valid to actually shoot through the door to kill somebody? Now, I say it would be a different thing if he was lighting your house on fire. I think that would be reasonable to shoot through the door because someone who's trying to gain entry, who's breaking in, that hasn't successfully broken in yet, how is that narrative going to be to these broccoli stalks? That is what I'm trying to get to here, is be on that safe side. Don't let again, we talked about this before. A prosecutor in Florida may see this different as one county over, or 2 counties over, or within the same prosecution office may see the facts differently. So when you have a presumption of fear, you can use it, but don't intellectually say to yourself, if you're in Florida and someone's going through your door and eventually they're going to breach that door, that you're going to say, well, California statute 776.013 tells me that I have a reasonable fear that the person is going to be gaining entrance and I could probably shoot through the door and get away with it. Is that going to be your narrative? Again, we've been talking about brandishing. Whether it's legal or not, that's not the argument. This is what self-defense is. And where did I put it? I don't, it looks like I may have gotten rid of it. Self-defense with a deadly weapon is like a light switch turning on. It's either on or off. It's either go or no go. Okay, I should also say it's either on, off, and back off again. It could be going back on and off. But my thing is, with this, brandishing laws or relying that the bad guy is going to be going away, what does that do for your narrative? What does that do for your narrative? I mean, we talked about that one guy in his Charger who got out in front of the camera and trying to provoke the guy into it and took his gun out. Let's do it from the other point of view. Again, we talked about imperfect self-defense laws, where both parties aren't doing something right, but if everyone is in ordinary force, whatever happens in ordinary force, can we all agree that whoever introduces the gun has now elevated it to deadly force? Is that reasonable to say? Now, even in an imperfect self-defense law, that person who sees that the other person who has a gun out now can defend himself with deadly force, even though that may have started out as ordinary force. And he'll probably be going to jail if he is able to get that gun out of his holster and present it and take the person down who already has his gun out. He'll probably be going to jail for manslaughter, second-degree murder, whatever it is. It's going to be a reduced, hopefully it's going to be a reduced, mitigated sentence because of the person who brought the gun out to brandish. You got your firearms instructor may not know this stuff. And I am not a firearms instructor. I go out of my way not to be a firearms instructor because of this. I think it takes too much time and energy just to do self-defense law Now, we've talked a little bit about disparity of force. In that video that I had before, in the previous 2 videos that I did, the guy is obviously taller than the shorter guy. Is that an automatic disparity of force? It depends. Your narrative has to be pretty spot on if somebody is just taller than you. Now, the guy was probably, maybe 6'3", maybe 100 pounds compared to the 5'5", 130-pound guy. And the funny thing about it is that there was a study that just came out, and I'm not cracking on you guys that are 5'7" and under, but there is a study that came out that men who are 5'7" and under there is something called a Napoleon complex. All right, like the guy in the church. It is interesting that what I have seen, that shorter guys are getting into these incidences at a higher clip. It's just anecdotal evidence for me right now. But just because a person is taller is not an automatic reason, a disparity of force reason. He must have a position advantage also. And that is something that you guys need to take a look at in self-defense, because when we are talking about innocence, eminence, proportionality, avoidance, and reasonableness, you can have up to all 5 of those. And the reason I say we can have up to all 5 of those, because there may be some legal facts that will take away some in part or whole, like your presumptions, that we can go on from there. So again, I want to reiterate that when you guys get into self-defense law, do not go down the rabbit holes with these presumptions and try to figure out what would be legal and what isn't legal, especially with the presumption of fear. And some other states have it. I've seen Missouri that has similar verbiage as far as it goes. But really, do you guys really want to learn about more of the rabbit hole legal issue of presumption of reasonableness so you might possibly shoot through the door? Really? Is that really where you guys want to go? Stay on the safe side of innocence, eminence, proportionality, avoidance, and reasonableness. And more than likely than not, those 5 standards will set the tone for your narrative and the jury that you are a reasonable person defending your life or others from death or great bodily harm, and you'd be able to get through it. I won't go through that right now, okay? My name is Jeff. This is 2A Self-Defense Law. I hope this helped.